I'm Sharon Levine, a bankruptcy attorney with the firm of Lowenstein Sandler, and have been assisting the TWU in the American Eagle bankruptcy case. Although my focus is bankruptcy law and not labor law, I've been involved in virtually every major airline case since TWA in connection with the 1113 process. I've been involved in complex settlement negotiations under 1113, along with difficult trial experiences in many of the airline bankruptcy and other cases defending labor. We understand there is a substantial amount of information, and unfortunately some of it seems to be confused with regard to the 1113 process at American Eagle. American Eagle, like American Airlines, is involved in a restructuring in bankruptcy court in the Southern District of New York. We are before a bankruptcy judge. The purpose of a Chapter 11 bankruptcy proceeding is to allow the debtor to reorganize, restructure, and come out of bankruptcy. While the 1113 process provides some protections for labor, this is not an ordinary collective bargaining agreement negotiation, but very much a situation where the company is being given the opportunity to reduce labor and other operating costs. The Eagle Chapter 11 case, while related to, is still separate from the American Airlines cases, and Eagle is a regional carrier. It is different than American. It is operating in a different economic environment, and it is not unusual for a major carrier to use the bankruptcy process to contract with newer, different regional carriers to fly under either the American Eagle or the American Airlines name. Unlike Eagle, American does not have this challenge, but rather this tool as it works its way through its restructuring process. Unlike a mainline carrier, Eagle is more like a vendor to the mainline carrier that has the added burden of dealing with other regional carriers competing to take away American's business. Because of this, we expect things to move very quickly in court, unlike what you may have seen at American. Please understand that the company does not need a consensual agreement to come out of bankruptcy. In fact, that is exactly the point of Section 1113 of the Bankruptcy Code. The company can have the judge impose Section 1113 relief and come out of bankruptcy with its workforce exposed. While the concessions sought are difficult, consensual agreements can contain provisions for profit sharing, pay increases, and a claim subject to court approval, which is something that the company would not be obligated to provide without a consensual vote. It is also important to note that the agreements you will be voting on, like the last best offers voted on by the 7 TWU groups at American, would contain important bankruptcy protection provisions and incorporate all of the collective bargaining agreement provisions which you currently have, which are not modified by these tentative agreements. We understand that there may have been some confusion over the American APA ruling on August 15 that occurred during the first TWU Eagle vote. As you saw, American quickly fixed the 2 technical issues the judge identified, and the judge abrogated the pilot's agreement. Importantly, that ruling had nothing to do with our current case at Eagle because it dealt with 2 issues that are not present in our contracts. Some may also think that American's apparent lack of a fleet plan will prevent the judge from making a decision on our contracts at Eagle. This issue may not be sufficient to prevent the judge from making a decision to impose relief under Bankruptcy Code Section 1113C. The judge will look at the 9 elements courts generally look at in the 1113C context: whether the debtor made a specific proposal to the union, whether the debtor provided the union with relevant information to evaluate the proposal, whether the debtor met with the union to negotiate the proposal, whether the debtor negotiated with the union in good faith, whether the proposal was based on complete and reliable information, whether the proposal is necessary to permit a reorganization, whether the union refused to accept the proposal without good cause, whether the proposal treats all parties fairly and equitably, and whether the balancing of the equities clearly favors rejection of the agreement. Which, as you know, this negotiation already resulted in better changes to the tentative agreements as compared to the company's 1113 proposal. Remember, the judge will not pick and choose between contract terms. He will simply make a decision as to whether the company has met its burden under the law. If so, he will grant the motion and abrogate your contract, meaning you will have no collective bargaining agreement. The TWU is preparing and will be prepared to put on its case in connection with the American Eagle TWU 1113 trial. However, after an extensive and hard-fought trial in the American Airlines case, the bankruptcy court issued its August 15 opinion and more recent September 4 decision and made clear that with regard to the one contract where there was no ratified agreement, and I'm quoting the court now, the court grants American's Section 1113 motion and authorizes American to reject its current collective bargaining agreement with the APA. After granting the 1113 relief, the judge went on to say, "I hope that all the parties can move beyond my ruling today to do what they're going to have to do. In some ways, I'm the most important person here because I have to issue a ruling, and in some ways, I'm the least important person here because I have no ability to actually work out an agreement. And that's something that you all have to do, and I have no power to do it for you. And that is what your negotiations committee worked to do at the table, to preserve important contract terms and to avoid the risk of the judge abrogating your entire contract. Bottom line, we are in bankruptcy court. This is not a labor court. This is not a court that fosters collective bargaining. It's a court that focuses on paying close attention to giving the company what the company says it needs in order to reorganize, going to the judge and asking the judge to say no to Eagle, that it does not need labor concessions, is a very difficult ask. Please remember that a vote on the tentative agreement does not involve a simple choice between an acceptable or unacceptable contract. If the court imposes relief under Section 1113, you will then have no contract and no status quo. The TWU will then begin negotiations under Section 6 from a lesser position and without the benefit of a reopener or Me Too provisions. Please understand that no one can tell you how to vote. It is a highly personal decision that will affect you and your family for a long time. Please remember that this is a very important decision, and it is imperative that you make this decision based upon the best information available to you. It's important that you not act on misinformation or rumor. Talk to your family, look in the mirror, and make a decision that you will be comfortable with in the future.